Dear students, let us start the discussion on today's newspaper, that is 16th May 2016. Now, the first article is related to the free speech. So, recently Supreme Court in Subramanya Swamy case held that the criminal defamation under sections 499 and 500 of the Indian Penal Code are constitutionally valid. The arguments which the Supreme Court took are two. The Article 19(1)(a) that provides for the free speech has restrictions onto it, and a person's reputation also comes under the scope of the Article 21 that provides for the right to life to him. So, the Supreme Court has pitched the Article 19(1)(a), so which is believed to be having a chilling effect because of the criminal defamation against Article 21, under which it has concluded that a person's reputation is his fundamental right in the scope of the Article 21. The second argument it put forward is the societal fraternity or constitutional fraternity will be protected. A society will be held together because of protection of one's reputation. So the fraternity is the term which was used by the Supreme Court. Now in this case, the Article 21, it provides for the protection to the life and personal liberty of a citizen against the state. But however, the criminal defamation or defamation need to be seen as between two individuals, private individuals. And coming to the fraternity, understand equality, liberty and fraternity, these are the terms which are used in our preamble. And these three terms, they have come from the French Revolution. So, without equality, there can't be liberty, and without equality and liberty, the inequalities are bound to be high and the fraternity can't come, and it ultimately leads to exploitation of one by the other. So, we cannot separate these three things. It means the constitutional framers, they saw the fraternity from the perspective of the protection of the civil rights and the human dignity. On the other hand, the term fraternity and Article 21, which they are used to curtail the free speech in this particular judgment. So, the author argues this. In the criminal defamation, it was brought in a different context in UK, and it was used in a different context in India. And the truth is not a protection or defense against the defamation. It means that, for example, if I criticized someone and the criticism is truthful, in spite of that, he can file a defamation suit against me. And second thing is mistakes. So if you understand, honest mistakes can be committed, and even these honest mistakes are also not a defense against the criminal defamation. So in these circumstances, the criminal defamation which has come in context in different circumstances will not be a valid thing today. And coming to the money bill, the power to certify. Now, the context of this is the Rajya Sabha has a very limited role with regard to the money bill. It can only discuss, but it has, or else the role is very much limited. Only the thing it can do is it can delay the bill for a maximum duration of 14 days. Now, Aadhaar bill, Monetary Policy Committee appointment, even today amendments to the Foreign Contribution Regulation Acts, all these are done by the Parliament through as a money bills. As for Article 110 subclause 3, money bill has to be certified by the Speaker, or the Speaker certification is final with regard to the money bill. And Article 122 and 212 will not allow the courts to interfere into the matters of the legislature. Article 122 applies to the Parliament and 212 to the state legislatures. So in this context, does money bill needs a judicial review or not is the question. If Rajya Sabha's role has to be protected, money bill needs a judicial review. So that is what is the argument which has been brought forward over here. So the Rajya Sabha role is to protect the hasty legislation by the Lok Sabha under the popular pressure to appease the certain sections of the society. So in this case, the Rajya Sabha is given a definitive role as a check against the hastiness of the Lok Sabha. So here, the major challenge So the Rajya Sabha's work need to be scrutinized. The Lok Sabha's work need to be scrutinized. So the author compared that with the provisions of the criminal defamation, provisions of the anti-defection law. Under the anti-defection law, the speaker and the chairman of Rajya Sabha, speaker of Lok Sabha, they have the final decision on disqualification of a member. But however, in Kyoto Holohan case, the Supreme Court has clearly stated that this protection is only valid for a procedural irregularity, not for a substantive question of law or substantive irregularity or substantive crime which has been committed. So in this case, the Raja Rampal case, the Supreme Court has again held that if there is an account of substantive illegality or unconstitutionality, then they are not protected under Article 122 or 212 from judicial review. So if it is the same logic is applied for the money bill, the Supreme Courts can take a look into this matter and can restore the Rajya Sabha and its relevance in our bicameralism. So that is the essence of the article. Coming to this, now how nationalism can be perpetuated. If you take the Rajya Dharma, that is the essence of the state's function and its governance, is to make the people prosper and also to provide the sense of justice to all. But however, the states, instead of focusing on these factors, they are more and more focusing on symbolism, that is to raise a personal agenda. So in this context, what the author argues is the responsibility of the state and togetherness of the people, they do not come from mere sloganeering, but it comes from justice and prosperity to all, which the focus of the state has to be. Now, Foreign Contribution Regulation Act. Last year, there was a question on this. Now, let's see the context. So, there is a Vedanta group, and the shareholders of the Vedanta group, more than 50% of them are the foreigners. Now, this Vedanta has to fulfill certain conditionalities under companies law, that is corporate social responsibilities. So, in this case, so as per the existing law, any company which has got investments greater than 50% from foreigners, it will be regarded as a foreign company, and the funds to buy it, either to the political parties or to NGOs, they come under the scrutiny of the Home Ministry. They have to take the permissions under the Foreign Contribution Regulation Act. Now, the existing Amendment Act, it want to exclude these companies, the Indian companies which have foreign shareholdings greater than 50% from the scope of the law. It means that the funds given by them to the political parties or NGOs, they do not come under this Foreign Contributions Regulation Act. Now coming to the, Mauritius. I have already explained this article to you. So, for example, a person is a resident of a Mauritius and an Indian resident. Now he will send the money to the Mauritius, and from the Mauritius he will get invested that in an Indian company, and whatever the money he got or gains he made, profits he made, he will say that he will pay the taxes in the Mauritius, and the taxes in the Mauritius are zero. It's a tax heaven, so that he is evading the tax. For this, what we are saying is the double taxation avoidance agreement that is existing between the India and Mauritius is revised, and any Mauritius resident, if he has gained by investing in the shares in Indian company, he has to pay the capital gains tax in India. Between 2017 and 2019, it will be 50% of the existing rate. After that, it is going to be 100%. So, in this 2 years of window period, if a company is not spending at least 27 lakhs rupees as expenditure in Mauritius, it will be just recognized as a shell company, and it is supposed to pay the 100% of the tax. This 50% norm will not apply to them. And what the Prime Minister, the Finance Minister Arun Jaitley was saying is this: in these circumstances, India need not give tax incentives to attract the investments. Ultimately, it is the markets, the strength, markets have to depend upon the strength of the economy, strong fundamentals of the economy, which India is good at, so it will not worst affect the investments according to Arun Jaitley. And now coming to the another thing, India successfully test fires interceptor missile. What does this mean? Now, whenever a missile is fired from a foreign country, then that missile has to be intercepted from anti-ballistic missile which is fired from us. So this is what is called advanced missile defense systems. So a Prithvi missile was fired from a naval ship, and then it was countered by another missile which was fired from the ground. So this is what happened on the Wheeler Island. This is the missile defense system of India. So here there are two things. One is exoatmospheric, endoatmospheric. Exoatmospheric, it needs greater precision, but India's ballistic missile defense, whatever is tested, is endoatmospheric missile defense. Now, Iran and United States, they signed a nuclear deal. Now the sanctions though lifted on the Iran, it still suffers from certain challenges. So now, India has to pay more than $6.5 billion as part of its imports of oil and natural gas. But however, lack of proper banking channels, it was unable to transfer that money to Iran. As Prime Minister is about to make a visit to Iran, so the government wants to solve it out as to repay the 6.5 billion to the Iran. Along with that, the agreements are going to come on the Chabahar port, and also agreements are expected on developing, that is Farzad oil gas field, and a trilateral trade agreement will be brought between India, Afghanistan and Iran. These are the three are expected during the Prime Minister's visit. Now coming to the targeting of RTI in the House. You know that RTI is always an unease for many of the people. So the accusation on the RTI is it is being misused to harass the functioning of the public authorities, and it is ultimately dwindling the efficiency of the government. The frivolous complaints are coming up. In this case, a research was conducted by RAG Foundation, RTI Assessment and Advocacy Group, and also an association with the National Program on RTI. What exactly it says is this. Out of the total RTI applications, only 1% of the applications they proved to be vexatious or frivolous in the sample of 20,000. And the second thing is, most of the information requested, more than 70% of the cases, it could have been declared proactively by the government entities. As per the RTI Act itself, the proactive disclosure of the information is a required thing. But however, governmental offices are not following this proactive disclosure. That's why they feel they are overburdened with the RTI applications. So, the objective of the RTI is to create the informed citizenry. To the better, RTI's law shall not be diluted. And now coming to a buffer solution. So there are huge price fluctuations in India. So sometimes onions go way ahead of the price. This time it is the turn of the sugar. So what the author argues is, the editorial argues is, we are maintaining the buffer stocks for rice and wheat. So why can't we maintain them for onion and sugar too? That is what is the author talks about. So these are the articles for today. Now yesterday we had a good interaction with the Snehaja, who got the 103 rank, who was part of our mentorship program, and Rishant, who got 180th rank this year. So Snehaja got 206 marks in interview, Rishant got 204 marks in interview. So 208 I think is the highest mark in interview. These are the second and third highest in the interview this year. So one thing I observed is this, again and again, your focus, simplicity matters in this exam, and wish you all the best for the next year. Thank you very much.